2017 New York Times article titled, "Trump told Russians that firing the nut job Comey eased pressure from the investigation. Quote," and this is the quote that's in the article, "I just fired the head of the FBI. He was crazy. A real nut job. I faced great pressure because of Russia. That's taken off." Now, theoretically, Mr. Comey could sue President Trump for defamation, except for a couple of things. One, it's not generally considered defamatory to say someone has mental health problems, even if it's not true, because it's no more defamatory to say someone has a mental health problem than to say they have a physical health problem. It's part of life. And I know that a lot of people in this room are concerned greatly as a matter of public policy about what Donald Trump poses, even as you would act with the normal professional compassion and solicitude towards a person experiencing whatever he's going through. But the second point is that other people's mental health in our democracy in general is considered to be in the eye of the beholder. So a judgment that somebody is, quote, crazy, or a, quote, nut job, or a, quote, madman, or a, quote, basket case, as President Trump has variously called Comey, Glenn Beck, Lindsey Graham, Bernie Sanders, Kim Jong-un, and Jeb Bush, is all protected by the First Amendment, because it is generally treated as a matter in our First Amendment as one of subjective opinion. So President Trump can opine on other people's mental health, just as the people in this room, as real professionals, have every right to opine as to his mental health. In a democracy, we do not articulate questions of mental health generally as matters of official governmental truth. Okay? We don't have, for example, a mental health qualifications test for running for public office. In our Constitution, the only tests are those of citizenship, if you want to run for the House, Senate, or presidency, and there's different numbers of years you have to have been a citizen. Residency within a state, if you want to run for the House or the Senate, and there are certain age requirements, 25 to run for the House, 30 to run for the Senate, and so on. Well, if a state or the federal government wanted to impose a mental health test, we could not do it. We cannot do it. Anybody can run for office regardless of what their mental health is or their physical health. But there are exceptions to this idea that people's mental health is not a matter of official public concern, official government concern. One example, of course, is involuntary commitment of people to hospitals if they constitute a threat to themselves or to other people. Another is when a court, either a judge or jury, will make a formal determination about whether a person is not guilty by reason of insanity or lacks the mental capacity to stand trial or to testify in court. All of these judgments have been upheld against various constitutional attacks as within the proper powers of the government and is consistent with or indeed even compelled by due process of the law. Now, there's another place in our constitutional scheme where mental and physical health become relevant, and that is in the context of the 25th Amendment, which considers matters of utmost national concern and interest, presidential succession, and fitness. So let me just give you a little bit of the history of the 25th Amendment, which was added exactly 50 years ago to the Constitution in 1967. And it was adopted after the assassination of President Kennedy, when there was much discussion in both political parties about the problems of presidential succession, about the ambiguities in the current Constitution dealing with it, and also what to do about a president who becomes sick or is wounded and is unable to conduct the powers of office. So, if you look at the 25th Amendment, Article 1 of the 25th Amendment simply says that if the president leaves office by either removal or by death, the vice president becomes president. Article 2 of the 25th Amendment says that if the vice president is gone, if there's a vacancy in the vice presidency, the president may nominate a new vice president, and with majority vote in both houses of Congress, the president's nominee will become vice president. Section 3 of the 25th Amendment deals with the problem of if the president believes for whatever reason he or she is unable to discharge the powers and duties of office temporarily, he or she may turn those powers over to the Vice President. And that's been exercised, we've counted 5 or 6 times since the passage of the 25th Amendment. For example, when President Reagan underwent surgery and anesthesia, he temporarily and voluntarily turned over the powers of office to Vice President Bush. And then after the surgery was over and anesthesia wore off, resumed the powers by writing a letter under Article 3 of the 25th Amendment. Now, Article 4 of the 25th Amendment deals with the problem of a president who is incapacitated, unable to discharge the powers and duties of office, but is unable to certify to that effect for whatever reason. And there, they spent most of the time talking about this, and it's the most complicated part of the 25th Amendment, and it has never been exercised or activated, and that is what, of course, brings you together today. The first thing that we've got to see is the standard in the 25th Amendment is not a DSM standard, okay? It's not a question of whether somebody has a DSM diagnosis, or in Trump's terms, he would say whether someone is crazy or a nut job. That's not the question. The constitutional question is whether someone is unable to discharge the powers and duties of office, okay? Whether you can do the job. And that's an important point for, I think, everybody here to keep in mind. You come from a particular professional perspective, and you're thinking in particular diagnostic terms according to your profession. But that's different from the constitutional judgment of fitness under the 25th Amendment. And I would say that a determination that someone meets some DSM category is neither necessary nor sufficient to activate the 25th Amendment. It's not necessary because there are lots of things that could disable a president, including a heart attack, a stroke, dementia. The president could go missing the way some governors have gone missing. So it's not necessary that there be a DSM determination, nor is it sufficient. You know, if you're a student of history and you read the presidential biographies, there are lots of presidents who had maybe diagnosed, but certainly undiagnosed mental illnesses. You know, perhaps my favorite president, Abraham Lincoln, suffered from what they called in those days melancholia, would almost certainly be diagnosed today as depression, and yet he clearly was constitutionally able to fulfill all of the powers and duties of the office. So, and I think that's also an important point to keep in mind in terms of the mental health community. We don't want to say because somebody has dealt with a mental illness or is dealing with mental illness in their life, they're not capable of holding public office. It's just not true. And so the judgment that we're really talking about is not even so easy as can you fit this or that president into a particular DSM box. Okay. Well, how does the 25th Amendment, Section 4, actually work? Well, it's complicated, all right? And it's never happened before. So this requires some attention. And of course, one of the big problems we get out there is attention deficit disorder. Okay? So people need to pay attention to how it works. That's why I'm here to talk about the Constitution. I hope that there are no headlines out there saying that I have pronounced upon the mental health of this or any other president, with the possible exception of Abraham Lincoln, which I guess I just did. Okay, so how does it work? Well, it works like this. The Vice President and a majority of the principal officers of the presidency, by which we would translate that to mean the cabinet. Okay, so the Vice President and a majority of the cabinet, or the Vice President and a majority of a body to be set up by Congress, can send a letter to the Speaker of the House and the President pro tem of the Senate to declare that a presidential inability exists, that the President is unable to discharge the powers and the duties of the office. And at that point, the Vice President assumes the powers and duties of the office automatically if that happens. Now, what's step one? And Step one is the sending the letter. Step two is the vice president assumes the powers of the office. Now, step three, the president can transmit also to the Speaker of the House and the President pro tem a letter, a written declaration, that no inability exists. The president could do that immediately. The president could do it a week later, or the president could do it 6 months later, or 9 months later, okay? But the president could then send a letter back saying either there never was an inability, or there was an inability and it doesn't exist anymore, but it doesn't exist. The president at that point resumes power within 4 days, unless the vice president and a majority of the cabinet, or the vice president and a majority of the body to be set up by Congress, says that the presidential inability still exists, and the president is unable to successfully discharge the powers and the duties of the office. Now, if they do that, now we've got a disagreement. The president says there's no disability. The vice president and either a majority of the cabinet or a majority of the body say there is a disability. What happens then? At that point, Congress must meet within 48 hours. And the Congress must decide whether or not to stand with the vice president and whichever body has determined presidential inability. There needs to be a 2/3 vote. So this is a very high standard. There's got to be a 2/3 vote in the House and a 2/3 vote in the Senate to determine that there is in fact a presidential inability. During that time, the vice president is still the acting president. Okay, and either Congress votes by 2/3 to stand with the vice president and one of these bodies, or fails to muster a 2/3 majority, in which case the president resumes powers. The Congress has essentially stood with the president. Now, even if the Congress votes by 2/3 to say that there is a presidential inability, and therefore the vice president continues to be the acting president and to have the acting powers of the president, the whole thing could start over again. And similarly, if the Congress says there's no inability and the president becomes resumes the powers of the presidency, it could start over again. That is, the vice president and either a majority of the cabinet or a majority of the body set up by Congress could determine later, by sending a letter to the Speaker and to the President pro tem, that presidential inability has arisen once more. All right, so what do we see from this? Well, it's a very high standard, it's a very high bar, and it's a standard, of course, completely different from one of impeachment. The standard in impeachment is high crimes and misdemeanors, right? That's a judgment that can be informed by lawyers and by, criminal law professors and judges and so on. But ultimately, the determination of a high crime and misdemeanor is one that is assigned to Congress, okay? In this context, the standard is not high crimes and misdemeanors. The standard is whether there is an inability to execute the powers and duties of the office of the presidency. And it can be informed by the judgments of physicians and psychiatrists and the public and so on, but ultimately it's going to come down to the vice president, one of those two bodies, and the Congress of the United States to determine whether they think presidential inability and unfitness exist. Okay. Now, when I became a member of Congress in January, I was concerned about this, and I'm a professor of constitutional law, so I pride myself on knowing every nook and cranny of the Constitution, including those that aren't really much in use, and I've once written a constitutional law final exam question about the 25th Amendment, so I went right to it, but the first question I asked is, well, where is the body that Congress has to set up in order to act? And I got the answer back from the Library of Congress that Congress had never set the body up. There's no body, okay? And so my legislation, H.R. 1987, does not mention President Trump or President Lincoln or any other president, okay? My legislation simply establishes the body that is contemplated by Section 4 of the 25th Amendment to the Constitution. And the body the way that we've written it, and remember, we haven't had a hearing yet because the majority has not given us a hearing, so it's a work in progress like all legislation is. But the body that I envision is one that would be a blend of physicians, psychiatrists, and former statespeople, former presidents, vice presidents, secretaries of state, attorneys general, people who've occupied high office in the federal government. And 10 of them are appointed on a bipartisan basis by the Speaker of the House and the Minority Leader in the House, the Majority Leader in the Senate, the Minority Leader in the Senate, and those 10 people would then together choose a chair of the committee, who we assume would be a person of broad, multi-partisan or non-partisan standing and stature and respect in the country. And they would be the ones who would be assigned all of the powers that the body would have. Now it's important to think about for a second why the framers of the 25th Amendment, like Birch Bayh and Senator Robert F. Kennedy and President Eisenhower, who was very involved as a citizen in the movement for the 25th Amendment, why would they create a system where the vice president could act with the cabinet, or the vice president